Guys, the hearing opens with the father's attorney laying out a key argument about the mother's earning potential.
Is $32,000 a year. She's worked as a school para. That salary average in Kansas is $35,000 a year. And then on the higher end would be if she were to complete her degree and get social work or find something in the social work field, that can be as high as between $55,000 and $67,000 per year. We would ask the court to consider somewhere in those range rather than imputing her just to this small minimum wage, which makes a significant difference. I know that Ms. Hollingworth has an understanding with her new husband that he wants her to be stay at home, but we feel that it's more appropriate that she contribute more to the support for these children. I know that Ms. Soretti said that she did a multifamily application for four children, and that does show on the worksheet that she's proposed. I would also like the court to take into consideration the fact that my client has 2 stepchildren that he supports. So it's really a total of 6 children that he's supporting. I will say, and my client readily admits that the stepchildren, they get a small amount of child support, but it's a very dismal amount, and that he supports them by about 80% of their support. Finally, I'd also like to take a look at the income tax consideration. I didn't run another one to combat that, but $97 to my client seems like a very small income tax consideration. I'm not sure what Ms. Soretti used to come to that amount. If my client were to claim the children, he would have upwards of, $4, $5, maybe $6,000 in a credit each year. He has not claimed the children since 2019. Ms. Hollingsworth has claimed all 3 children during all of those tax years. So with that being said, Your Honor, we would just ask that there be some additional consideration to the child support worksheet itself. We don't have any objection to the filing status that Ms. Soretti laid forth, that she filed in March, and that it would be April 1. It just has to do with the factors that I just laid before the court. And we would just ask you to give consideration to that.
All right. Thank you, Ms. Huntington. Ms. Mann, before I let you respond, I might just inquire of Ms. Soretti. Could you explain your methodology in arriving at I believe it was $97 tax adjustment?
Your Honor, that I use the Bradley software, so I could provide the court with a copy of the income tax considerations portion of the Bradley printout that is included with the software. Additionally, the guidelines indicate that an MFA is not allowed for children who are covered by another court order, especially when there is support ordered in that case.
Right. Okay. And Ms. Mann, would you like to respond to either Ms. Soretti or Ms. Huntington's assertions or requests?
Judge, all I would say is that we agree with Ms. Soretti's calculation of the child support and her comments regarding an adjustment for the 2 stepchildren. I was also going to mirror that statement. Just regarding my client's ability to work, the last time she was in school, and as counsel had noticed or indicated, she does not have a social work degree. She would have to go back to school in order to get that. She was last in school back in 2010. And then she did work at a daycare as a para, and that was all after the parties separated. It wasn't like a career that she had. It was to make ends meet. So the amounts that are provided on the proposed child support worksheet, we would ask the court to adopt.
Your Honor, I failed to mention one other issue that I was asking the court to consider. There were a couple of years in there due to COVID where there were some additional monies that went back to parents who claimed children on their taxes. So that should be considered as income, additional income for Ms. Hollingsworth during those tax years.
Okay. Well, I appreciate all of the parties' arguments. In all candor, I am not yet settled in terms of my decision with at least respect to one of the considerations that Ms. Huntington asked the court to take into account. And so I will be continuing to think about that for a moment, but I think in the meantime, if the parties are comfortable doing so, even before the modification question is fully addressed, maybe we could take up your other motion, Ms. Huntington, concerning cash payments in the case. I am in receipt of your trial notebook, and I have had opportunity to review the various submissions you had made in terms of documented payments that were made by check. I also understand that you're asserting that there had been some additional monies, and from the point of view of your client, meaningful, perhaps in the area of $10,000 and just cash payments made. If you'd like to speak to the court about those issues, I'd be happy to hear that.
The judge steps in with a question about the tax adjustment that appeared in the worksheet, specifically the $97 figure that had been calculated. One of the attorneys explains that the number was generated using Bradley software, which is commonly used for child support calculations.
Thank you, Your Honor. What I'd first state is I'm not offering this as an excuse, but more of an explanation. My client was pro se at the time that the journal entry went into effect. He did not understand that it wouldn't be treated and counted as child support if he did not pay it through KPC. That's just how the parties agreed to do it, and that's how he started doing it. For the majority of the payments since the time of the journal entry, he made those through check, which, as Your Honor has acknowledged, and well, not acknowledged, but receipt of Exhibit L, which is included with the individual checks were written to Ms. Hollingsworth. Those were all for child support reasons. There were no additional payments in those checks for anything other than that, no direct expenses or anything. It was strictly for the child support obligation, which was set at $400 per month. It's also our testimony that the blank spaces on our summary that we've provided, Your Honor, in Exhibit L, it's our testimony, and my client can be asked to be sworn in and give testimony about it, that those were cash payments that he made to Ms. Hollingsworth. I know that counsel is going to respond and say that the majority of these payments she will acknowledge. I don't know how many, but I'm not sure what she'll say about the cash payments. But my client tells me that sometimes he would have cash and he would just hand cash to her. He didn't get a receipt. They didn't do any kind of documentation for that. He does tell me that there were times when Ms. Hollingsworth would say, the way you're breaking these up, sometimes he'd pay 100 and then 200 and then 400, was causing her a little bit of difficulty with managing her expenses. But there was never any argument or allegation that he wasn't paying the child support as he was ordered by the court. So I think that further supports our argument that the cash payments were made during those times on the numbers that are blank on our summary for the court. Your Honor, it's our testimony that we believe that there is no arrears owed, with the exception of if the court's going to go back to April and start the new child support, then obviously he would owe more for those 2 months, April and May. But other than that, Your Honor, we are asking the court I know that the court makes the assumption that those were gifts. We're asking the court to not view them as gifts, but view them as child support payments made to Ms. Hollingsworth, and to also, in addition to the checks that have been provided, to recognize and state that the cash payments that my client made to Ms. Hollingsworth should also be counted to in effect, do away with any child support arrears. We're trying to seek an order too, Your Honor, because there have been steps taken not by Ms. Soretti, but through Kansas Department of Transportation. They've given him notice that they're going to suspend his license because of the arrears. So it's important for us to get this resolved. My client tells me that recently he also received a second letter saying that they're going to do a report to his credit agency, which would have a severe negative impact on his ability moving forward if he has a very low credit rating. So we're hoping that the court can help us get this resolved today, and my client can put that behind him. Thank you, Your
All
Honor.
right, thank you. Ms. Mann, as Ms. Huntington has offered, I'm very happy to swear in both Mr. Leslie and your client, Ms. Hollingsworth. At the same time, if counsel are comfortable stating their positions and with the court understanding, I think pretty much at least what Mr. Leslie would allege. I'm also just happy to go directly through to your position on that. So with that in mind, would you like me to swear witnesses, or would you like me to just hear your perspective from your client's point of view?
No, I think we can proffer both, and that's fine.
Okay.
I will say, Judge, and Ms. Huntington, I don't have your exhibit notebook, so I don't know what we're referencing as far as how much direct payments were made to my client. And maybe you sent it to me, and I apologize. It's been kind of a crazy week. My client does admit she kept some of her own records, and she does admit receiving direct payments. And I have a spreadsheet myself, but we do come up with an arrearage owed still of about $10,000. So we are acknowledging receipts, but I don't know what that is saying he's paid to compare notes. We at this time, it's my understanding that all of the money is owed to mom, none of it's owed to the state. And at this time, until we can do some accounting of our own, comparing notes, we're not willing to waive any arrearage that would have been accumulated because it was cash. And we would want the court to consider that gifts. It's my understanding that at any time, mom can determine and to waive child support arrearage that might have accumulated. And I'm not suggesting that that isn't off the table, but at this point, as of today, I can't say yes, there is no arrearage, because I don't know what dad's numbers are.
Okay. And I'm not positive. Give me a second to refresh my recollection. And if you've been, yes.
The courtroom turns to the father's claim that he also paid significant amounts of child support in cash. His attorney explains that when the divorce order first went into effect, her client was representing himself and didn't fully understand that payments had to go through the Kansas Payment Center to count officially.
May I address those?
Yes, please.
Okay, Your Honor, the paragraph 18 of the journal entry of decree of divorce file stamped 11/30 of 2018 includes IWO language, which there has never been an IWO issued in this case. However, paragraph 17 of the journal entry of decree of divorce file stamped 11/30 of 2018 includes Kansas Payment Center language and directs all payment to be made through, shall be made to the Kansas Payment Center with all of the information on how to make those payments. So DCF's position is that these are presumptively disallowed and construed as gifts. And like I said, the outstanding arrearage listed within our system is $27,144, and no payments have been made since we obtained an assignment in this case either.
Well, I think that what I was going to mention, and thank you, Mr. Reddy, for DCF's position and that background. The motion from Ms. Huntington on Mr. Leslie's behalf, wanting to have this question resolved, indicates that there's a total child support to be calculated of $26,800 over the course of the time since the order was originally made in the case. And I do see a significant number of checks and in meaningful amounts that I do understand where Mr. Leslie is coming from, and asking that the court at least consider against the presumption that those would be counted and that would be credited to him as far as payments on the case. I understand that beyond those checks, which I think total something like $16,000, there's an assertion by Mr. Leslie that he had paid in cash something on the order of $10,000. And so I understand where Mr. Leslie comes from in terms of believing that if the court were to go against the presumption and give him credit for those amounts, that could reduce the arrearage balance to zero or something close to that. I also understand that Miss Mann is fairly new to the case, and given what she had explained about the press of business and other busyness over the recent days in her life, I'm grateful that she has been able to apply the effort that she has to represent her client on this case. I'm wondering if, in fairness to Miss Mann, and since she does not have in her receipt the information that's currently before the court, if we might do well to continue this just to give Miss Mann an opportunity to look at the documents and consider with her client, A, whether there were any cash payments, and B, if there were, whether those should be potentially credited to Mr. Leslie. Does that make sense from your perspective, Miss Mann?
Yes, sir, I appreciate that.
Okay. And I think that I will take under advisement the modification question too. There's at least one piece of that that I would like to settle in my mind. And I just understand that there's at particular issue, the question of whether or not the court should ascribe anything higher than minimum wage. And a lot of numbers have been offered. And I understand too that there's a balance that goes in the direction of parties having an opportunity, and that it's in many ways desirable for them to live life and apply their energies as they think is best for themselves, for their kids. And I just need to think about that a little longer before I make a decision. I would like to try to get this resolved as quickly as is practicable. We do have, I believe, a possible date on July 19th, and I wondered if that date would be workable for either of you.
That works for me, Judge.
All right. And Ms. Soretti, July 19th, I suppose would work for you.
I'll be
Uh,
here, Your Honor.
Okay. And Ms. Huntington, does July 19th work for you and your client?
It does work for me. Yep, works for both of us.
Okay. Let's set it at 3 o'clock that day, July 19th, 3 p.m. And if you could please forward the information you had provided to the court, Ms. Huntington, to Ms. Mann. And then as far as this other pending motion is concerned, if the parties would like for me to, I could ask Judge Crum if he would like me to handle that issue when we reconvene on the 19th. And the alternative, if you wanted to try to get that sooner before a court, you could potentially reach out directly to Judge Crum's office. But I will at least make that ask that question, and if Judge Crum would like me to resolve it, I'll be prepared to do that on the 19th as well.
I know that we had sent around some dates, and we may actually have a date already set for that. We
Okay.
understood that you probably wouldn't want to hear that or have the time to hear it today. So I think we're good.
Okay.
Can-
August 12th at 10 is when it was set.
Yeah.
Okay. Good deal.
Yeah, perfect. Thank you.
Perfect. Well, we will look forward to seeing each and all July 19, 2024 at 3 o'clock in the afternoon. And I'll be prepared to rule on the modification motion, and I'll be prepared to hear more from you, Ms. Huntington and Ms. Mann, after the information is exchanged, and to try to determine if there is any common ground, and if not, to hear any other testimony or any other argument that you have at that time.
Okay, Your Honor, I just want to make sure, will you leave the door open then for swearing the witnesses in next time if we have to come back?
Yes, ma'am.
Okay,
Yes,
thank you.
ma'am.
Honor.
After hearing both sides, the judge carefully sums up the situation. He recognizes that the father has provided a substantial number of checks that appear to represent real payments. The judge also says he needs additional time to think about the earlier issue regarding the mother's potential income and how that might affect the child support calculation. With that, the court schedules the next hearing for July 19th, where the judge expects to revisit both the modification request and the disputed payment records.